webinar, Clarity Put on Hold as FTAIA Conflict and Confusion Continues. My name is David Pulio, and I'm with Foley and Lardner's Marketing Department. On behalf of Foley, I'd like to thank you for joining us for today's conference. Before we begin, we do have a few housekeeping announcements. Today's program will last approximately 1 hour, followed by a short question and answer session. We do encourage our attendees to submit written questions throughout the program. Please type your question into the Q&A widget open on the left-hand side of your screen. We will respond to written questions at the end of the program, time permitting. The webcast console you're looking at can be completely customized. You can resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. If you experience any technical difficulties during the presentation, please visit the webcast help guide by clicking on the help button below the presentation window, which is designated with a question mark icon. The PowerPoint presentation will be available on our website at Foley.com in the next few days, or you can get a copy of the slides in the resource list widget open to your left. As a reminder, today's program is being recorded and will also be available on Foley's website within the next few days. Foley will apply for CLE credit after this web conference. If you did not supply your CLE information upon registration, please send it via email to me, David Pulio, at dpulio@foley.com, the email address that you see on your screen. To be eligible for CLE, you will need to log in and view this presentation on your computer and answer a polling question that will be posted during the program. And as a final note, those seeking Kansas, New York, or New Jersey CLE credit are required to complete an attorney affirmation form in addition to the polling question that will appear during the program. A 5-digit code, actually, will be announced during the presentation. Please email the form, again to me, David Pulio, at dpulio@foley.com immediately following the program. Now, I'd like to introduce our presenters for today. We have with us today Melinda Levitt and Howard Fote, partners in Foley and Lardner's Washington office and sometimes the Brussels office. Melinda Levitt is a partner in our antitrust practice. Her practice focuses on complex commercial litigation, including antitrust, securities, and class action defense work in matters pending before federal and state courts as well as various federal agencies. She also regularly publishes and speaks on e-discovery developments and is a member of the firm's e-discovery and data management practice. Prior to joining Foley, Ms. Levitt also worked at the U.S. Department of Commerce as an import specialist. Her work in that area has included anti-dumping casework and counseling and representing clients before the Office of the United States Trade Representative, the European Commission, and various other governmental trade officials. Howard Fote is a partner and another member of our antitrust practice, as well as the international and automotive practices and our life sciences industry teams. Mr. Fote counsels and represents corporate clients in international and domestic trade regulation laws, multinational mergers and acquisitions, international antitrust, distribution and franchise matters, the transfer and license of intellectual property and technology, and the law of the European Economic Community. He also represents export trading companies and other corporate clients before the International Trade Commission and in similar venues concerning export licensing, documentation, and various other matters subject to the Export Administration Act. The extent of Mr. Fote's international practice often requires his presence at Foley's office in Brussels. And with that, I'd like to turn it over to our presenters and would like to wish everyone a wonderful webinar. Thank you.
Thank you, David, very much. Again, my name is Howard Fote, and I'll be initially starting the program today. Welcome, good morning, good afternoon to all who have joined. This is a presentation that we hope you will find to be of current topical interest, and we will try during the presentation to define with as much particularity as possible why it should be important to your practice and to your clients or to your companies for whom you are working. In terms of our overview of the presentation, we're going to take you back almost 50 years, not quite 50 years, to the 1970s, and talk about the issues that were perceived as facing the United States, particularly as the United States turned increasingly outward in its focus and was confronting challenges from around the world. One of the responses to that concern, to that antitrust uncertainty, was the Foreign Trade Antitrust Improvements Act of 1982, which we will be discussing in detail and analyzing its various components and suggesting some continuing difficulties that remain with the language of that act and how it's been interpreted by courts ever since. As I said, it will be clear, I hope, from our presentation that despite the good intentions of the Congress and the administration that ultimately enacted this law, there are continuing problems of interpretation, continuing conflicts in how it should be applied, and those problems came to a head. At least we had assumed that they were coming to a head in the last several years, 2013, 2014, and indeed earlier this year, with a series of federal Court of Appeals decisions that seemed, certainly facially, to be in conflict with one another. Indeed, as you will see, several of them involve the same international price-fixing conspiracy and raised FTAIA issues, and the courts in the 7th and 9th Circuits came to different conclusions as to the applicability of the FTAIA to the conduct that was before them. And we will try in conclusion to decide where we will be going from here.
Howard, if I can
Sure.
say what this will mean, is, as I'm sure everybody will see as we go through this, as much as we will try to discuss what the FTAIA says and means, unfortunately, there is no definitive answer because of this ongoing conflict between the courts of appeals that the Supreme Court has not yet reconciled. So all of this remains in many ways an open question.
So, to move back in time to the 1970s, a time which some of you may remember, perhaps many of you do not remember, but it was a time of a reality check for the United States. In 1974, the OPEC imposed a boycott on exports of oil to the United States and rapidly caused a major economic crisis in the United States. There were many people who were decrying the way in which U.S. Laws were being enforced, and there were a number of federal district court decisions which seemed to suggest that the U.S. antitrust laws were available to anyone, anywhere in the world, who had a perceived competition problem, whether or not that restraint of trade had any consequences in the United States. out of that series of very conflicting decisions came several courts of appeal decisions that are listed on the slide that you have on your screen now, slide 5. But unfortunately, the courts in deciding those cases developed differing tests on the type of conduct in international trade that would violate the Sherman Act. There was as well a growing uncertainty and concern about the extent to which, as a matter of priority and principle, U.S. law should be enforced extraterritorially. So in the context of this period of uncertainty, critics of antitrust law sought to solve this problem by clarifying the antitrust law applicable to export trade, and as well by limiting U.S. antitrust law and its extraterritorial reach. So as Congress considered this legislation, it was met with a wide variety of commentators, witnesses, and other people that presented the issue to them, who I think said pretty clearly that there was no consensus on how far U.S. antitrust laws could or should reach into export trade activities. There had always been, since 1918, legislation that sanctioned export trade conduct by groups of U.S. companies, and that legislation, the so-called Webb-Pomeranian Act, was felt by many U.S. interests to have important value that was also being threatened by the way in which U.S. law was being interpreted. So as I said, proponents of change sought to limit the application of U.S. antitrust laws to restraints occurring abroad that had a direct, substantial, and reasonably foreseeable effect on U.S. domestic competition and commerce. And they sought to limit the ability of foreign purchasers to have access to U.S. courts and to force them to rely on their own local law to redress their perceived competition problems. And at the same time, to underscore the continued support for joint export trade activity that had been embodied in the Webb-Pomeranian Act. Indeed, as will be seen, they set up a parallel system of antitrust exemption to further support joint export trade. So, with that, I think I'm going to turn back to Melinda and ask her to take the next few slides.
We're going to look for a moment at actually what the statute says. This is unfortunately one of the most poorly drafted statutes. It has caused tremendous amount of confusion as to its exact meaning and how to read it. The Third Circuit has referred to it as being inelegantly phrased and using rather convoluted language. I think that's a compliment to it. It is baffling to most people who try and read it, but let's try and walk it through. It was enacted in 1982, and it sought to achieve clarity, which is ironic given how poorly it's written. The FTAIA focuses on international trade and says that the Sherman Act, the United States antitrust laws, apply to competitive restrictions affecting U.S. import trade, but does not apply to competitive restrictions affecting trade or commerce with foreign nations. in other words, non-import trade, unless such non-import conduct has a direct, substantial, and reasonably foreseeable effect on trade, which is not trade with foreign nations, meaning domestic trade, import trade with foreign nations, or export trade with foreign nations by a person engaged in the U.S. in such export trade. And such restrictive effects give rise to a claim under other provisions of the Sherman Act. I'm sure that was clear to everybody. Again, this is tortured language. Courts have said it's tortured language. And it creates, unfortunately, a series of exceptions within exceptions, and courts have grappled with this from the beginning. So even though the FTAIA was supposed to provide a clear benchmark on what it meant and what was domestic and foreign trade and what companies could or could not do, finally, at least in 2004, the Supreme Court did have an opportunity to consider the FTAIA in a case called Empagrin, which I actually prefer referring to as the vitamins case, in which the Supreme Court ruled that the FTAIA limited, not increased, antitrust jurisdiction of the U.S. courts, meaning no global power over antitrust claims. And that was very important because there was a debate when the legislation was enacted or during the time it was being developed about whether or not somebody in the United States could bring a claim saying companies abroad are engaging in a conspiracy, whatever, and I'm being hurt, but not here in the United States, but being hurt somewhere else.
Melinda,
for example.
let's put into context what the Empagrin case involved. As you said, it was
about vitamins.
Call it the vitamin case. There was a series of investigations around the world of vitamin companies investigated under U.S., European, Brazilian, Japanese, and potentially other antitrust jurisdictions. And there was, at the end of the investigation, enforcement proceedings brought against a number of vitamin companies who were alleged to have, for many years, agreed either or both to fix the price at which vitamins were being sold in various jurisdictions, or to allocate among the participants in the conspiracy the territories in which they would sell, thus eliminating any price competition.
And the vitamins, of course, were completely fungible. Vitamin C tablets, vitamin E, whatever. They were the same product throughout the world.
And so there then were a number of civil actions brought in the United States by a variety of allegedly injured plaintiffs, and the Supreme Court ultimately had to decide where the lines were to be drawn in this kind of international context. Back to you.
And that's how the case came up to the Supreme Court. The Supreme Court said that the U.S. courts needed to discourage forum shopping and avoid unnecessary interference with the sovereign interest of other countries to regulate their own economies. In other words, whether or not Japan's antitrust laws were however they wanted to decide their own laws and enforce them in their own countries, the United States courts were not to interfere in interpreting Japanese laws applied to Japan or to other countries besides the United States. But the court did hold that a global price-fixing cartel, which directly significantly and would reasonably foreseeably affected both customers in and outside the United States. But where the adverse effects were independent of domestic effects, left plaintiffs relying on the foreign effects with no claim under U.S. antitrust laws. Where exactly that line is of course the rub. It's very difficult to figure out where to draw that line. Therefore, seeds of confusion and conflict that had been planted continue to grow, and the FTAIA has been dogged by all of these conflicting judicial decisions ever since. Howard, I think it's back to you. Howard?
I'm sorry. Importantly, the seeds of confusion that had been sown both prior to and as a result of the Supreme Court's 2004 decision became even more problematic in the years that followed 2004 because antitrust had really become a global phenomenon. In the first years of the 21st century, increasing numbers of countries around the world enacted antitrust regimes, so that now today there are over 150 countries that have antitrust laws and regulations of varying degrees of seriousness and enforcement priority, but virtually all of them focus on and prohibit conduct that would be per se illegal under the U.S. antitrust laws prohibitions in the Sherman Act, price fixing, market divisions, and other cartel activity. As a result of these antitrust regimes being enacted, there was an explosion of antitrust investigations, prosecutions, and increased regulatory cooperation around the world that has raised the stakes for business and for individuals. It is not uncommon, for example, in the United States, for there to be more than 50 grand jury investigations occurring at any one point in time. And as U.S. enforcement officials at the Department of Justice point out, many of them involve international activity. The auto parts investigation, which continues to take increasing numbers of companies and individuals within its ambit, has resulted in more than 30 companies and more than 35 individuals being charged with violations of U.S. antitrust laws. All of those companies operated outside the United States. Fines and damage claims that have resulted from the investigations and prosecutions and treble damage actions have literally involved billions, if not trillions of dollars in the United States alone. As I said, many of those challenged activities had a global or at least an international nexus. Thus, it's not surprising that since U.S. courts, even with the enactment of all of these other antitrust laws, remain the only principal forum in the world in which both treble damages and attorney's fees can be awarded, there is a concomitant tremendous demand for access to U.S. law, and to U.S. courts by persons wherever located who are claiming to have been injured by reason of an antitrust violation. As should be evident, that demand collided directly with the FTAIA and its purpose to limit and clarify the reach of U.S. antitrust laws. As I guess should be further evident, the results have become and as we will say, continue to be increasingly contentious. We're going to focus now on 4 important issues that courts have considered when they have been interpreting the FTAIA. First, is the FTAIA an issue of substantive liability, or is it an initial question of subject matter jurisdiction? And as a corollary, why does that matter? What are the consequences that flow from the question how that issue is to be resolved, both for private plaintiffs, for defendants confronted with treble damage claims, as well as to perhaps a lesser extent, the United States government, who through the Department of Justice enforces the FTAIA. The second question is, what is the scope of the import commerce exclusion? As you will recall from Melinda's description of the law, that the exception that the FTAIA creates does not apply to commerce that is in import trade, commerce that is trade directly with the United States. In the context of such import commerce, the standard age-old provisions of the Sherman Act would fully apply and would prescribe restraints in such import trade, just as they would prescribe the activities of a domestic cartel that had no international context whatsoever. However, if the import commerce is indirect, the question arises whether there can be an effect on import commerce, so as to bring the challenged restrictive trade practices within the ambit of the FTAIA. And then in any event, and perhaps as symptomatic of the problems that have arisen in interpreting the FTAIA, the law requires that the effect to be actionable has to be direct, as well as substantial and reasonably foreseeable. And so there is, as you can imagine, a major dialogue about how much directness there must be, and what is direct and what is indirect. And then finally is the question how to interpret the requirement in the legislation that the domestic effect has to give rise to the claim being asserted. And as will become important later on when we talk about the issue of the federal government's ability to use the FTAIA in criminal prosecutions, the issue has arisen whether that authority exists given the requirement, the very short but important word, and that not only must the effects be direct, substantial, and reasonably foreseeable, but they also have to give rise to the claim being asserted. So there is a question whether, despite the logic that might exist for the proposition that U.S. criminal prosecution should not be inhibited or frustrated by such a technical requirement, there is a question whether that power which they are continuing to exercise is being lawfully undertaken. So we're now going to discuss a number of pending cases that have raised these issues, and I'm going to turn back to Melinda for the first two. Pardon me, the first
one, right? And I'm going to be discussing the Lotz case, or Lotz. You'll see on the screen that this is a Second Circuit decision just last year, and it touches on many of the topics that we've already begun to highlight for you. First of all, who can come into the United States courts and try and rely on the U.S. antitrust laws to deal with conduct that occurred abroad? In this case, we have Lotus, who is a Taiwanese manufacturer of UBS devices. UBSs are incorporated into, we all have those UBS plugs that are incorporated into computers. He claimed, or Lotus claimed, that, and again, he was Taiwanese, a Taiwanese company, which had certain factories in China. Claim was that the Chinese competitors in China eventually set certain industrial standards within a trade group, which ultimately, through a series of actions, prevented our plaintiff from being able to have its UBS products purchased abroad and incorporated into computers and similar devices that ultimately would be exported to the United States. Okay, so we have a Taiwanese person coming to the United States saying activity of a conspiracy in China kept him or its company out of being able to sell products in China that ultimately would be incorporated into larger products that would be imported in the United States. The alleged harm was prices in the United States are going up because with the absence of Lotus being able to compete in China, the manufacturers of UBS products were more limited and they could increase their prices. The first question the court looked at was whether the FTAIA raises a question of jurisdiction or substantive merits. Now, again, because what does that mean? If it's just jurisdictional, it means it can be decided on a motion 12b-6, simply on the pleadings. If it's substantive, the court's going to need to look later at a different point as to the actual arguments and factual background and evidence to determine whether or not a claim can go forward. And in this case, the Second Circuit said, no, it is not jurisdictional. It cannot be, an FTAIA claim cannot be dismissed on a 12b-6 motion, but rather is one of substantive merits that must be examined in more depth. The court also held that the domestic effects do not need to be immediate. In other words, and they disagreed specifically with the Ninth Circuit in a prior case, which held that the harm felt in the United States had to be immediate based on the conduct that happened abroad. In other words, a conspiracy to raise prices by foreign manufacturers. When the product was imported in the United States, those prices would then go up. That's an immediate effect. Remember, here we have a product being made in China that is then purchased in China or other foreign countries, then used as an input product into electronic equipment, and that electronic equipment is then what's eventually sold to the United States, with that UBS device being but a small portion of the computer or whatever's being sent. That's indirect. The Ninth Circuit had said that it has to be direct. The Second Circuit here said it does not need to be immediately direct, but rather only has to have a reasonable proximate causal nexus. The harm only needs to have a reasonably proximate causal nexus to the action that was taken abroad that is alleged to be unlawful. So things are sounding okay here for the plaintiff. However, ultimately the court came to the point and said the problem here, and the reason this case cannot go forward, is that the plaintiff's injury was not the same as the U.S. domestic injury. The effect, if there were an effect in the United States, which would be the increased prices of UBS using equipment, that wasn't the injury, though, that the plaintiff faced. The plaintiff's injury actually was that he was kept out of the market, being able to participate in China. In other words, the plaintiff did not face increased prices in the United States, but merely he had come to the United States ultimately, according to the court's analysis, to complain about being kept out of the Chinese market for UBSs, and saying to the court, and by the way, there's also a harmful domestic effect here in the United States because prices are going up. The court said you don't have the harm that the United States consumer is having, and therefore the FTAIA is not a vehicle for relief from you, and you cannot be in the United States courts. Howard?
Yes, thank you. To compound the confusion that Melinda has so aptly described, I'm going to be talking about two cases, the AU Optronics case and the Motorola AU Optronics case, that arose essentially at the same time out of the same price-fixing conspiracy that involved wholly non-U.S. Participants in the price-fixing conspiracy, principally Asian manufacturers of liquid crystal display LCD devices that many of us have in our televisions and in our mobile phones. The issues started with a grand jury investigation in the United States that has resulted in a number of companies, AU Optronics being one of them, and a number of individuals, the individual Hui Huang being an official of AU Optronics, being charged with violations of U.S. criminal law, the U.S. Sherman Act's criminal provisions, and for purposes of our analysis, as you can appreciate, most of these liquid crystal display panels are manufactured by foreign persons, sold to foreign third parties, and are incorporated into electronic products that are then imported to the United States.
And Howard, am I correct? In fact, I don't believe there are U.S. domestic LCD manufacturers.
No. that there are none.
Right. So everybody here was foreign.
Everyone here was non-U.S. Absolutely. So in this context, at least in this particular case, the conduct involved exclusively indirect imports into the United States. This was not a situation in this case, in this criminal case, where the government was challenging direct sales by the company AU Optronics into the United States. However, the Ninth Circuit upheld the conviction of the individual, despite the contentions of the individual that the FTAIA barred his prosecution on the basis of a prior case in the Ninth Circuit, the LSL Biotechnologies case decided in 2004, that the conduct here, despite despite the fact that it was involved indirect imports, had the relevant direct effect, because according to the court in this 2015 decision, relying on the 2004 Ninth Circuit decision, the effect was an immediate consequence of the price fixing, of the trade restraint. At the same time, unlike the U.S. federal criminal prosecution, there were a massive number of treble damage suits brought in the United States by a wide variety of allegedly injured plaintiffs, and there was a multi-district litigation panel sitting in San Francisco that handled certain pretrial proceedings, but one of the companies, Motorola, opted out of the class and pursued its own action against AU Optronics in the Seventh Circuit in Chicago. The claim by Motorola involved exactly the same conspiracy that had resulted in the conviction of the Taiwanese and individual in the Ninth Circuit case. In this instance, Motorola asserted a claim arising out of LCDs being bought by Motorola's foreign subs, which then incorporated those LCDs into their phones, into Motorola branded phones, and then sold those phones or transferred those phones to Motorola in the United States for resale.
So Howard, just to emphasize, so we have Motorola, a United States company, standing before the court in Illinois, and then ultimately the Seventh Circuit saying, "Hi, we were harmed because our foreign subsidiaries were forced to purchase higher-priced products abroad that were ultimately brought here. So we, Motorola, were hurt as well as the U.S. economy was hurt, right?"
Right.
So we got finally we have a domestic plaintiff complaining about what's happening abroad.
However, despite the result in the criminal case, the Seventh Circuit held that with respect to those sales of LCDs that arrived in the United States through Motorola's foreign subs, there was no sufficient directness to hold AU Optronics liable here. Indeed, contrary to a decision in an earlier case, which had, as Melinda had alluded to earlier with respect to Lotz, interpreted directness as meaning a reasonably proximate cause of the claimed injury. So this was one of the cases, along with the criminal case, that were appealed to the Supreme Court and were ultimately chosen not to be heard by the court. So back to you, Melinda.
And again, so the Seventh Circuit there is in direct conflict within the same year with the Third Circuit in the Lotz case, which said that no, you don't need to have these immediate effects. You can have you just need to be able to show a causal nexus. Now, what's the Third Circuit have to say? Looking at animal science products versus a group of Chinese companies. Now we have, again, a U.S. domestic plaintiff. The case was brought by U.S. importers of Chinese magnesite, which I assume is how you pronounce that mineral. They claimed that the Chinese producers conspired to fix prices for the products sold in the United States and probably elsewhere. The district court looked at that claim and said, you know what? I don't think you've got jurisdiction under the FTAIA, and granted motion to dismiss under 12b-6 on those grounds. Third Circuit took a look at this and said, nope, that's not right, that the FTAIA does not just is not a jurisdictional bar. Rather, it goes to a question of the substantive merits of the actual claim, and therefore remanded back for the court to consider what to do. So we have a dispute now between, we've got the Third, the Seventh, the Ninth, and the Second Circuit. Nobody agrees on jurisdiction, on the question of what is direct, who can be a valid plaintiff or not. Why do we care about substantive liability or subject matter jurisdiction? For those of us who litigate, this is a very big question. For those of you listening who are with corporations, it's also a major question because it ultimately comes down to a significant question of cost. Where a court looks at the FTAIA as being a question of subject matter jurisdiction, again, the case can be then heard on a motion 12b-6. Court can decide whether or not, under the terms of the statutes and the way the complaint is written, assuming it also would meet the standards of Twombly at this point in terms of sufficient pleading, the court can determine whether or not a claim has been stated and make that decision before any discovery has gone forward, before the parties have spent an inordinate amount of money on that discovery. It also means, though, that the case can, if you're the plaintiff, can go away very quickly, and you don't get a chance to bring forward the evidence that you'd like to. If the question is one of substantive liability, then the court is going to have to consider or allow for some level of discovery to go forward, which is extremely expensive, especially in these types of cases. It's going to involve discovery from abroad. And courts throughout the country talk about the expense of antitrust discovery. In fact, the Twombly case was in many ways decided on the fact that courts should not just let cases go forward willy-nilly and force parties to engage in the tremendous expense of antitrust discovery. And on whether if the case is going to be considered in terms of the substantive merits, the burden is now placed firmly back on the shoulders of the plaintiff who brought the case, whereas in a 12b-6, it's defendants who have the burden of proof to show that the complaint as brought is not sufficient to allow a court to go forward. The emerging majority view is that the FTAI is a question of substantive merits. and not a fundamental question of subject matter jurisdiction. Again, that is not universally held, with the implications being there that the FTAI cases will proceed at least through all that expensive discovery and take several years to get through that, and then await either a decision on summary judgment based on what's come through all of that discovery, or indeed a trial for resolution. Therefore, to the extent defendants were hoping to knock cases out early on, it appears that an emerging majority view is not to allow that to happen and to have these cases go forward. The Third Circuit in Animal Science, the Second Circuit in Lodes and Ninth interpreted the question of substantive liability, and that was consistent with a 2006 Supreme Court case, which was not an FTAIA case. But again, what does this mean? And we look at a case called Minnesota Chemical. The defendants, is it Minnesota Chemical, Howard, or is it?
MinChem. Just
MinChem. The defendants independently there imported potash into the United States from Canada. And the plaintiffs complained that defendants had conspired with Russian potash producers to fix the price of potash sold in Brazil and Asia. And there was little to no evidence that the price-fixed potash sold in the foreign markets had affected U.S. prices at all, or that the potash imports from Canada were tainted by the alleged price-fixing conspiracy in foreign markets. The Seventh Circuit ultimately affirmed a denial of defendant's summary judgment, meaning that the case would go forward, which then, at that point, defendants went ahead and settled for around $100 million. Letting cases go forward to summary judgment puts tremendous pressure on both sides to settle, to avoid expending the cost of all the discovery and or the cost of trial and all the risks associated with that, and almost the inevitable appeal that will happen afterwards.
So let's look at the next question. For an effect to be direct, what is required? I'm sorry, I think I have skipped.
Yeah, you skipped a slide.
One slide, excuse me. There we go. The scope of import commerce exclusion. So does the conduct affect import commerce? Keep in mind that if it involves import commerce, FTAIA doesn't come into play. So are there limits on the question of effects? So it's an easy case where the defendant makes and sells goods abroad and sells them directly to the United States purchaser. FTAIA wouldn't even apply. But what if the defendant is not the importer? What if any competitive conduct directed at an import into the United States? There's obviously a relationship to the direct effect criteria as well. And perhaps as our iteration of the cases has now confirmed, there is a conflict between appellate courts in the Third, Ninth, Seventh, and Second Circuits on this issue. So for an effect to be direct, what is required? It is this issue of directness that has sparked most of the controversy, as we've discussed.
And I think which we had hoped the Supreme Court would have helped decide.
Right. The Ninth Circuit continues to apply an immediate consequence standard, a temporal context. The Second and Seventh Circuit, at the urging of the United States government, has adopted the rule that the effects must have a reasonably proximate causal nexus. It doesn't have to be immediate, doesn't have to be immediate in time. They have said that if the effect is not direct, if the effect filters through many layers and finally causes a few ripples in the United States. So there continue to be conflicts on the question of directness. And as a result, the Supreme Court was asked to, but has, for the moment, decided not to confront that question. And then the final element of our analysis, an effect can be direct, reasonably foreseeable, and substantial on U.S. commerce, but nevertheless, does that domestic effect give rise to the claim being asserted? As Melinda described in Lotz, a foreign USB manufacturer's claim was denied because it was not the same as a U.S. consumer's claim for increased prices. In Motorola, a parent corporation was denied being able to sue for inflated prices paid by its foreign subs that were imported into the United States. There is, of course, a relevant Illinois BRIC issue with respect to indirect purchasers, which Motorola in this case was. But nevertheless, is that a further gloss on the question of whether the domestic effect gives rise to the claim being asserted? And I guess, in addition, the question arises whether an indirect purchaser can ever satisfy the criteria of the FTAIA, and poses, I think, the question, why should Lotz lose its ability to recover the damages that it clearly, or at least certainly allegedly and for purposes of the litigation, was assumed to have suffered?
And I think, Howard, that goes back to the philosophic approach we discussed at the beginning, about who can, that I think Congress grappled with and the people pushing for legislation. The question being, who can come into the United States courts and have the benefit of the treble damages and attorney's fees, et cetera, in order to state that claim. And I think the Lotz is a good example of the view that, no, just anybody, you can't come here or use our courts and really complain about what happened to you abroad. And by the way, it also happened to have a negative effect in the United States.
And then, of course, there are two subsidiary or related questions. First, virtually every state in the United States has an antitrust law, and many of them permit indirect purchasers as well as direct purchasers to recover actions. And then, as I said at the beginning, there is a question yet to be resolved, whether this gives rise to the claim being asserted requirement precludes a U.S. Criminal prosecution of these cases. Excuse me. So what lies ahead? I hope, we hope, that we have demonstrated in this presentation that there is substantial confusion and conflict about how the FTAIA applies and to what conduct it applies. It seems to date that it is fair to say that there may be differences in the answer depending upon who poses the question. To date, the U.S. efforts to enforce its criminal laws have not been derailed by reason of, but because of the requirement that the effect give rise to the claim asserted. In addition, there seems to be some question whether there is a difference between whether a private plaintiff should be accorded more or less deference. And then is the final question whether there is proper deference being paid to a foreign government's antitrust regime. I'll turn it over to Melinda to provide some further concluding thoughts. Thank you very much.
I think that we've seen what the confusion that continues to exist, and again, why it's important for our listeners in terms of being either a producer, an importer, a purchaser of products abroad, an importer, what risk you take in whatever actions are you may be pursuing, or in terms of the claims you may be trying to bring. What is a domestic effect giving rise to a claim, as we saw in those cases? The ongoing uncertainty about whether it's the statute raises questions of jurisdiction or rather substantive liability, and all of the cost and risk associated with trying to bring a claim with that issue being left unresolved. Again, we had very much hoped the Supreme Court would have taken the conflict between the Seventh and the Ninth Circuit on the Motorola issue and begun to give us some clarity. Many of us were very disappointed when they denied cert in that case, and it has left this morass of confusion out there. And maybe the ball is back in Congress's court. I personally would appreciate very much if they would scrap the statute and rewrite it, and this time write it with the thought in mind of all of these cases that have now tried to interpret it and come up with a clear statement. However, given the present level of functionality with the United States Congress, I don't think we're going to see that in the near future, unfortunately. And so anybody who treads in these waters needs to continue to be very careful and monitor the situation as we go forward. And with that open question and that continuing sense of risk, I'll say goodbye to everybody, and thank you very much for listening, unless anybody has questions.
Thank you very much.
At this time, I'm going to read the CLE code for this program. If you are in need of CLE credit today, please enter this 5-digit code into the poll question you see in the slide area, and then click the Submit button. The code is BLQFF. That's B as in Bravo, L as in Lima, Q as in Quebec, F as in Foxtrot, F as in Foxtrot. That's BLQFF. And again, if you are seeking CLE credit for Kansas, New York, or New Jersey, in addition to entering this polling question, you will need to complete the attorney affirmation form and return it to me, David Pulio, at the conclusion of this program. A copy can be found in the resource list widget, which is open on the left-hand side of your screen. I'm going to leave this open for just a couple more seconds here. Again, one last time, the code is B as in Bravo, L as in Lima, Q as in Quebec, F as in Foxtrot, F as in Foxtrot. All right. And if there are any other final questions, please do submit them via the Q&A widget that is also open on the left-hand side here, and we will attempt to answer any that we encounter here.
I see a question has come, that being, does the FTAIA have any bearing on determining whether a U.S.-based company is considered to have participated in illegal anti-competitive practices in foreign venues. And an interesting question. The answer is not immediately, because remember, the FTAIA was designed to be a limiting statute, not an expanding one. If a United States company is engaged in illegal, what the United States laws would regard as an illegal practice abroad, but that conduct has no effect on the United States, however effect may be defined, then no, the FTAIA would not have any immediate implication. On the other hand, certainly if a U.S. corporation is engaged in some sort of conspiratorial activity where we're dealing with a product that is a widget, let's say that is a commodity, and U.S. purchasers bring a claim against the company and everybody else is conspiring, at that point I don't think the FTAIA would immediately apply, because the regular U.S. antitrust laws would kick in. So I don't. The FTAIA really isn't focused so much at that U.S. company at that point. I believe that would be the proper answer, but of course we'd have to ask several appellate courts how they'd feel, and I'm sure we'd get 3 different opinions.
And I do believe that's the extent of the questions that we've received. At this time, we will close down the presentation. And I would just like to remind our attendees to please take the time to complete the program evaluation, which will be popping up on your screen shortly. We do take our attendee comments seriously and use them to shape our future programs. So thank you all for attending, and we wish you a pleasant day.
Goodbye, everybody. Thank you very much.